had to upgrade my pedigree, so I wanted to come to UNL, but they wouldn't take me, so I went to Creighton. Here I am. Now if I can figure out how to change all this. Okay, space bar. I recruited Brother Linder to my firm, Koley, Jessen, a little over a year ago. And shortly after that, he asked me, "You're not going to leave, are you?" And I said, "No." And long story short, I ended up leaving. But I trained him up pretty good for about a year. As far as I can tell, he still has a ways to go. But my former partners tell me there's hope. No, I'm really pleased to be here with Tom and Mike and everybody. Thank you, Professor. I want to, I will just keep walking around, but I don't want to put a death grip on the podium, so I'm going to try to find a way. The presentation that Tom just gave us was really strong on analysis, and it was right on, and that's the kind of thing we need as lawyers. This speech is going to be more of a 20,000-foot overview, and it's something that I've been watching, and I know John Heil's been watching, and probably knows way more about than I do. And I think it's something that is incumbent upon Nebraska lawyers, and especially those of us who have any connection to agriculture, need to be watching. And it has to do with sediment loads in the Mississippi River Basin. The Clean Water Act, I won't go through the whole thing, but you know, we got the Clean Water Act, and what it does is establishes a framework, and the EPA implements the framework. And one of the things we do is require the states to do Section 303 lists, impaired water lists. They do an inventory of all the waters in the state, and then they decide whether that water is impaired or not according to numeric criteria established by the state. And the impairment goes on a chemical by chemical basis. What's the biggest pollutant that we have is sediment. Another one is nitrogen. Another one is phosphorus. Okay, where do all those things come from, right? And then we got some toxics mixed in there that come out of the end of the pipe. And well, there's some clean water. That's what we're trying to keep. So the way Congress did it is they made something called the National Pollutant Discharge Elimination System, NPDES, or you may hear people say NPDES. And basically that says that you cannot discharge effluent from a point source unless you have a permit issued by the state, if it's a state-run program, or by the EPA. I don't know of any EPA-run NPDES programs, but I imagine they're out there. But the key here is that this law applies to point sources. What's a point source? Well, it's any discrete conveyance, like a pipe, or it could be a ditch or a trough where water is discharged into a river, creek, or stream. And if it contains pollutants, it's a problem. Now, what can be a pollutant? Well, it could be clean water, but it could be at a higher temperature than the fish in that stream can stand. It may have a different pH than the habitat in that stream can stand. So it doesn't necessarily mean that it has to have toxics in it, or phosphorus, or other agricultural nutrients. The Clean Water Act does not regulate non-point sources. Well, what's a non-point source? Basically, the EPA says that's everything that's left over. And so if you think of a cornfield, or you think of a golf course, be it in the city or the country, that's applying lots of pesticides and fertilizers, the rainwater and the snow melt runoff pick up those things and deposit them into the rivers, creeks, and streams. And so you have discharges happening all the time that are unregulated. And that's a big, I guess you could call it a loophole in the Clean Water Act. So you saw on a previous slide, the Clean Water Act's been around since '72, and it is actually an amendment to the Rivers and Harbors Act of the late 1800s. So we've had water concerns for a long time. But the point I want to make is that we're at the point in the development of environmental law and regulation and enforcement where much of the low-hanging fruit has been picked. And I would call point source discharges low-hanging fruit. If you have any clients who have a factory, or if you have a municipality as a client, you know, municipalities have treatment works, and those treatment works treat the sewage, and the sewage eventually is discharged after it's been treated. Well, the municipality can't do that without having a NPDES permit. And so through federal and state efforts, you know, the Clean Water Act has worked really well to get everybody who ought to have permits onto the permit bandwagon, and those permits regulate those discharges, and we got a pretty good handle on those. But non-point sources are a different story. Here's just a slide example of non-point source. I don't know how these are coming out. Not my clients, but this looks to me like a cattle feed yard that's set up pretty darn close to a little stream there. So here's examples of non-point source pollution, excess fertilizers, already mentioned those, herbicides, insecticides, grease, oil, toxic chemicals. So the parking lot at the mall, you know, we all go there and our cars drip a little bit of oil, and the rainwater picks that up, goes into the storm sewer discharges into the river, creeks, and streams. So I'm leading up to something here, trust me. Here's what the EPA says. States report that non-point source pollution is the leading remaining cause of water quality problems. Effects of non-point source pollutants on specific waters vary and may not always be fully assessed, but they know they're harmful. Pretty sure everybody in here knows what a watershed is, but I like this slide because it's colorful and I like to look at pictures. But this is just an example of a little watershed that's gathering up the water on the hillsides and running it into a pond that's in lower elevation. And I wanted to use that to lead up to the Chesapeake Bay case. And there's been a lot written, and you could give a whole day seminar on this case, but Chesapeake Bay was extremely polluted, and the federal EPA and surrounding states spent a lot of money and are continue to spend money trying to get it cleaned up. I understand it's improving, but the federal government, we're here to talk about the effect of federal regulations on water quality during this panel. The federal government stepped in and did something that had not been done before, or at least as effectively, and they created what's called a total maximum daily load for various chemical constituents and physical constituents that were causing the pollution in Chesapeake Bay. I'm going to talk about total maximum daily load very briefly. This is just a map to get you the setting of where, you know, Chesapeake Bay is. You know, I think they raise their soybeans over here and their corn up there, and no, I don't know what they raise there. But here you got a slide, and this is the nitrogen load in pounds per acre. And you can see, you know, the bays down there. The red is the highest load. The lightest, or the dark green is the lowest load. So I don't know exactly how they get their nitrogen loads. I'm not that familiar with the state, but nitrogen is a culprit. Here's a report card. There's lots and lots on the web about this. So that's a health scale. And you've got different watersheds surrounding it, and they've rated it. You know, it looks like C is about in the middle. Red's very poor. Green is very good. You know, there's not much green on there. Okay, so I already mentioned this. EPA has established the Chesapeake Bay total maximum daily load. That's not a new tool. I'm going to talk a little bit about that. A historic and comprehensive pollution diet with rigorous accountability measures to initiate sweeping actions to restore clean water in the bay. So when the states make their 303 list, you have a list of all the waters in the state, and water may be impaired or not impaired. It may be non-impaired for fishing, but impaired for swimming. It may be impaired by different things. I already mentioned them: sediment, phosphorus, nitrogen, toxins. What do you do about it then? Well, one thing that can be done is the state can establish a TMDL, total maximum daily load, and what that means is if you're a point source discharger, let's take the Platte, for example, in Columbus. If you're a point source discharger there, like a factory or a municipally owned treatment works, those TMDLs are going to tighten the limits in terms of the concentration of what you can discharge. So that's the tool in the EPA and the state regulatory agencies' toolbox to fix the problem with impaired water. Well, EPA applied that tool on a federal level on a multi-state basis to try and clean up Chesapeake Bay. And that was applied not only to point sources, but also to non-point sources. Agriculture was directly affected. Here's just a slide more on TMDLs. I've kind of summarized it already. So what they did in the Chesapeake Bay case, nitrogen, phosphorus, and sediment TMDL has been developed for each of the segment watersheds there. And I wrote, what does that mean for businesses, homeowners, and agricultural producers in the Bay Area? So here's another slide of a watershed. I liked it too. Now this is pretty shocking, and I think it's at least 1/3 of the United States, but the Mississippi River watershed runs from the Rockies, from the Continental Divide, all the way to the Appalachians. The Ohio River and its tributaries discharge into the Mississippi. The Missouri River and its tributaries discharge in the Mississippi. And it all lands down in the Delta. Here's a slide highlighting erosion on cropland. That would be sediments that are ultimately entering the Mississippi and the Delta. This is a slide of the ag basin. The purple blotch at the bottom is what they're calling the dead zone. The red dots are ethanol plants. You can see the corn belt is delineated by a red circle line, not a circle, but a line. And then you got nitrogen used on crops. The red is more than 1,000 kilograms per acre, per square kilometer per year. Less than 10 is green. So you can see what's happening there. Nebraska, we're yellow. Iowa, Illinois, Indiana, all red. So we've got a lot of nitrogen going on. So it's 6 large watersheds empty into the Mississippi Delta. This is a slide we found of the confluence of the Missouri into the Mississippi, and it looks like the Missouri was kind of muddy that day. So there's the Delta in an infrared view. I don't know exactly what the red shows, but I think it's probably a satellite photo, probably infrared, and I think it shows I think it shows anaerobic conditions. So I'm not a scientist, I'm a lawyer, but what I understand is that the nitrogen loads overfeed the microbiological organisms that live there, and they multiply too rapidly and use up too much oxygen. There's not enough for everybody else, including the fish and the plants. And so you get what's called a dead zone. If you've been on the golf course and you see a pond with green scum, that's an anaerobic pond. They need to get a fountain in there and oxygenate that water somehow. Well, that's happening on a giant scale in the Mississippi Delta. So how do I back up? Okay. So in 2008, there were several environmental groups that sued Linder's friend, Lisa Jackson, who was Obama's first director of the EPA, and said, look, this is a mess. We got to do something about it. We want you to establish numeric limits for discharges of nitrogen, phosphorus, sediment, and probably other things in the Mississippi River basin, 1/3 of the United States. And the EPA said, nah, we don't need to do that. First they petitioned the EPA to make a rule. EPA said, no, we don't need to do that. The states can handle this. So then they sued in federal district court and said, Judge, the EPA won't make a rule. We want you to make them. So they filed this suit in 2008. A lot of states have jumped in. EPA agrees there's harm occurring, but they're going to work with the states. That's our federal system, right? That's the way it ought to work, in my opinion. They claim that there's overwhelming evidence of existing harm. Probably everybody agrees on this. But the problem is there's a risk that this litigation could trigger a court mandate, and we see it all the time where the environmental groups sue the EPA to make a rule, and not just in the clean water area, for federal numeric nutrient criteria. Mississippi is the largest river system in North America. Its basin stretches from the Rockies, all the way to New York State, and drains all or part of 31 states. So the impact could be enormous. What do you tell your farmer clients when, there's a rule that says they can't use as much nitrogen as they want to? So in the fall of 2013, federal district court issued a mixed ruling, and basically they split the baby. They ruled in favor of the plaintiffs that the EPA should not have denied their petition for rulemaking, but on the other hand, they didn't stop the EPA from making a decision on whether it was really necessary to have a federal rule or not. So that case is now on appeal. It was remanded for further action, and as I understand it, the court ruled that the EPA didn't have to make a rule, that it was within its discretion. It was up to the EPA to determine whether it was necessary. So, covered that. So here's what, this is off an EPA website. Currently, non-point source pollution control is mostly voluntary, unless you live in the Chesapeake Bay area. And there's other suits like this. There's one in Ohio and there's one in Florida. What can we do? Well, these I won't say entirely voluntary, because if you're a confined animal feeding operation, you got to do some of these things under your permit. Manage animal waste, right? Protect drinking water using less pesticides and fertilizer, reduce soil erosion, use planned grazing systems, dispose of pesticides in containers and tanks in an approved manner. So here's my question to all of us. Will these and other practices become mandatory? And I don't know if you've ever dealt with record keeping and reporting on any environmental permit, but I tell clients that if you have a Clean Water Act permit, you have a Clean Air Act permit, you're a generator of hazardous waste, and there are a lot of companies that have all these things. It's like filing 7 to 15 tax returns a year, because you got to keep all the records throughout the year that go with these things. You got to bring them all into one report, and that's for your clean air permit. It's for your NPDES permit. So it's a lot of work, and I have friends and family who are in farming, and I don't know. I don't know if this is coming on them as a mandatory thing or not. What would be penalties for non-compliance? What happens if you're caught putting on too much nitrogen? Or what happens if you don't file a report on how much nitrogen you used last year when it was due? Who's going to inspect? How big is the EPA going to get or the state agency is going to get. I don't know. So those are, that's the big picture of what could be down the road for us, and I just wanted to alert everybody to it. If you have questions, I'll try to answer as best I can. Okay, thanks for listening, very attentive, and hope to see you all again sometime. Thanks.